question. That has been discussed. In fact, a labor attorney brought that question up to me yesterday.
Point of information, can you repeat the question?
Yes. The question is, what about amending the act to allow workers with an unfair labor practice to go to court instead of just to the board, since the law has no effective penalties today, and the penalties under the act may not be strong enough. And I think there's a good question about whether the penalties under the act are strong enough. I think we made a number of judgments when we were working with Senator Kennedy's and Congressman Miller's staffs to draft the legislation and come up with the legislation. And some of those some of those judgments we made had to do with political and legislative viability. Your idea, the idea of allowing workers to go to court for a redress of unfair labor practices has been discussed, and it's been brought up by a number of union side labor attorneys. It was brought up to me yesterday in Clarksville, in Indiana. I would simply say this in response to that. There are a number of things that any one of us could imagine adding to the Employee Free Choice Act. The restoration of the right to strike, fixing common situs ticketing, and a number of other things as well. So nobody in the labor movement contends that this act will by itself fix all of the problems. I mean, one glaring problem is the millions of workers who are still excluded from the act. Farm workers, for instance, domestic workers, and others. And this act does not address problems that still remain in the Railway Labor Act. So we're not presenting the act as a perfect response to everything that is troubling or wrong with American labor law. It is a simple, straightforward, narrowly drafted bill to address the most flagrant violations of the freedom to form unions and bargain collectively.
Any other question? Yes, in the back.
This is actually geared toward Mr. Johnson. It's just if you can clarify. In one of your statements regarding card check, you said that we will not allow such a transfer of power to happen with regards to the Chamber of Commerce. And it resounded almost like the CEO, and I forget which company it was, when he said that we're in the driver's seat and we're not going to give anybody else the wheel. Okay, but my question is that infers that you recognize that there is a weight of power one way rather than the other, and that you're accepting the fact that that power is right now in the hands of the employers. So I'm just asking if you can clarify.
Yeah, no, I appreciate you that, because I must have mumbled through that part or got it wrong. I was referring to the arbitration provisions, not the contract provisions. And again, the arbitration provisions state that when a union and an employer fail to come to an agreement, they go through mandatory reconciliation, and then if that doesn't work out, a panel of arbitrators will write the contract governing the terms and conditions of employment for the employer. You're right, we are not going to turn over how to run our companies to a panel of arbitrators. That's what I meant. Obviously, in the union-employer negotiation, traditionally there is eventually a meeting of the minds and a contract is written, and when the unions and the employer is both on site, both of those have a role in running the workplace. So I appreciate you clarifying that, because I was referring to the contract provisions, and I apologize for that.
Yes.
I've been a union representative for quite a few years. I've signed a lot of contracts with a lot of people, including people in your organization. As a matter of fact, the reason we're in Indiana today is because I had dinner with somebody in your organization. Probably I was ready from your organization. He's an employer. He's always been a good employer. for our members. He's put a lot of people through college. He's taken really good care of a lot of people. And from his perspective, talking as we've become friends over the years, from his perspective, he believes that the card check thing is a good thing because it allows him to not have this unfair competition. He's a very gracious man. He's certainly difficult to negotiate with, but at the same time, when we negotiate a deal, it's good for him and it's good for me. By no means do I ever think or believe that any arbitration panel it's in their best interest or it's ever been in the union's best interest to put a company out of business by writing their rules and regulations. We want companies to succeed so we can employ more people. That's the reason why we're here. I can't believe that when you can't constantly say this, that you really believe that an arbitration panel is going to tell the hardware store down the block how to run his business. That's never happened in the labor movement as long as I've been.
Well, that's what the bill says right now, and so I'm just reading the bill. With regard to, it's only like 8 pages long. With regard to each member, I probably know him, but I have a labor relations committee. You know, I don't make this stuff up. I wouldn't have my job for long. I tried that once and almost lost it in the immigration context, but which we do work with the unions quite closely on, by the way. I have a labor relations committee made up of lots of companies across the economic spectrum, and they tell me what our position ought to be on these bills. Obviously, we have some dissension in some cases. I can tell you it's nothing like I got in healthcare when I got pharmaceutical companies and traditional employers and hospitals and various medical associations sitting on our board. It's a lot more difficult. But that's how we set policy at the chamber. There are some who don't disagree with us that are our members, but we have a policy approach, and that's what we do.
Yes, right here.
Yes. Thank both of you for coming here. Very interesting. Very, very interesting debate. I just have a couple of comments and questions and maybe some information. Mr. Acuff started out when he was talking about CEOs and so forth. When we attended the University of Wisconsin's school, we found out that the gentleman that come up with the merger between Exxon and Mobil. This gentleman got $147,355 and some change a day for 15 years. Now, when he was sick, it didn't matter. He still got $147,355 and some change a day. When he retired after 15 years, the company gave him over a $300 million retirement package. And for doing such a good job, they gave him over a $400 million bonus. My question is, and how many of those folks that worked underneath this CEO got any of that money or any praise? Mr. Acuff said something about misleading and lies from the company side. And Mr. Johnson, if I may, can you deny or confirm whether that's a kind of a lie there about this campaign that the companies have been spending over $200 million against this Free Choice Act? I would like for you to comment on that if you can.
Well,